All right, let's go ahead and do it, guys. So let's start our webinar for the morning, Resident Altercations and Landlord Liability. And again, thank you to the Greater Cincinnati and Northern Kentucky Apartment Association. I know we have a lot of you joining from that apartment association, and they are sponsoring this webinar. So again, thank you. Let's go ahead and move into just a quick agenda that you guys will see. I'll do some introductions, and then we'll do a quick overview. Neighbor versus neighbor disputes and violence, kind of how, some scenarios that Melinda here has experienced with those, kind of how to handle those. And then we'll jump into a little bit about sexual harassment as well as domestic violence. Then really deep diving into how to de-escalate those particular situations and how to kind of capture the proper documentation to protect yourself. And then ultimately how surveillance technology can help, again, protect you from that liability that you're exposed to with having residents and resident altercations. Then we'll end with a Q&A. And that being said, if you have questions come up over a specific topic that we're covering, throw it into the chat and we'll address them as they come up. But we'll have a quick Q&A at the very, very end to address any questions that you guys have. So again, thank you for joining. We also have Maggie from Cincinnati and Michelle from Colorado. Thank you guys so much. We're really glad to have you guys here. So I also have here Melinda Macbeth. She is with Offutt Kerman. And so she is a litigator at Offutt Kerman, and she's spent 8 years representing landlords and property management companies in matters that really relate to residential and commercial real estate, including lease construction, fair housing disputes, administrative agency complaints, breach of contract defense, and civil litigation. So she is definitely a wealth of knowledge when it comes to this topic. So again, Melinda, we're really glad to have you here. Thank you for taking the time.
Thank you. I am glad to be here. This is something that we've been doing semi-regularly now, and I always have fun. So I am looking forward to this one. I think this is going to be a good topic.
And then just a quick introduction of myself. My name is Jen Free. I am Director of Sales with Cloudastructure. My background is on the operations side. So I've been a property manager. I've been a regional manager. So I've been in a lot of your guys' shoes in terms of dealing with these resident altercations and kind of learning how to properly handle those to protect myself and our company. But that's really where my passion comes for what I do with Cloudastructure, because if I would have had AI surveillance and remote guarding on my properties, it would have made my job so much easier. So I love really sharing the wealth of knowledge in how AI surveillance and technology can save you time and save you money on property, because again, I have felt your pain and I know what it's like to watch hours of footage. You don't even know if you're going to find what you're looking for. So Melinda, take a moment to really give us a high-level overview of Offutt Kerman.
Offutt Kerman is a full-service civil litigation law firm. We are one of the fastest growing law firms in the country. We are currently an AmLaw 200 law firm, which means that we are among the top 200 revenue grossing law firms in the country. We continue to expand. We just announced the addition of an office in Atlanta, Georgia. We also have offices in Florida, in California. I believe we are also going to be expanding to Dallas, Texas soon. We have offices in Virginia, North Carolina, Washington, D.C., Pennsylvania, New Jersey, New York, and where I am based in Maryland, which is also where the firm was founded. I am based out of the Baltimore area office, and I live in Baltimore City. We have different practice groups in the firm: family law, trust and estates, and I am part of the landlord representation group. I mostly exclusively deal with landlords in the state of Maryland, but we also have attorneys who handle DC, Virginia, New Jersey. Pretty much wherever we have an office, we have someone who can help you with your terrible tenants or with your good tenants, because I've heard that those exist too, even though I have not met them.
Well, again, thank you for being here, Melinda. We're happy to have you. And just a quick overview of Cloudastructure and what Cloudastructure has to offer. So I kind of briefly mentioned, but AI surveillance solutions and remote guarding solutions is the idea of bringing technology together with human intelligence to really hone in and making your security infrastructure more of a proactive approach to security, as opposed to reacting to something that has already happened and trying to cover your bases there. So the idea that you have a live agent that is watching your feed that can do a talk down in real time and intervene when they need to keep it from progressing to further unwanted activity. So they're able to say, hey, you in the blue hoodie, you need to leave immediately. You're in a monitored area. We're going to contact the authorities is super helpful. And that's where we've held strong with a 98% deterrence rate of deterring that unwanted activity from progressing. So just imagine instead of walking into your leasing office in the morning to find out that four of your, vehicles, resident vehicles were broken into, or there was a resident altercation that ended really poorly the night before. Instead of that, you would walk into reading your emails and finding an incident report of this is what our guards deterred. And a lot of our clients have been able to use those incident reports to really apprehend the suspect. So you'll kind of see how that AI surveillance and technology can really come into play with protecting you and your company because you're covering all your bases. You have that surveillance that you can show, the footage that you can show, and that documentation that will really protect you in the long run. And I'll jump into that a little bit more later, but that is cloud structure. And again, we're happy to have all of you here. So let's go ahead and jump into the meat of the webinar. So we'll talk about some of the data and statistics surrounding resident altercations, and then we'll jump into some of the differentiations, and Melinda will share some of her horror stories that she's dealt with in the court and how to properly handle certain situations and protect yourself. So some of the data surrounding insurance costs have been on the rise since 2018. They've soared by increasing 129%. That's 7 years ago. 27.7 year-over-year increase in just 2023, and it's continuing to increase in the double digits over the last couple of years. According to the National Apartment Association, 61% of multifamily owners and managers had to increase their deductibles to keep their plans affordable. And insurance companies are pulling back. They're pulling out of certain states and withdrawing in high-risk states like California due to the sheer volume of claims. They aren't making money, so they're pulling out and they're no longer insuring these states. So it's definitely a problem that's on the rise, and getting to the meat of the problem is the biggest key. Protecting yourself, deterring these resident altercations from even happening in the first place. Every single year, 1 in every 4 multifamily properties faces a security-related liability lawsuit. One of my really good friends works for a company that just settled a $3 million liability lawsuit. And that's huge. So you can imagine that. I mean, that kind of money can be spent towards installing surveillance on your property and deterring that stuff from happening in the first place. But you can kind of see some of the differentiations here between assault and battery, sexual assault and rape, wrongful death, robbery, false imprisonment, and some other ones. But the approximate share each of those have within the total cases that are being seen with resident altercations. And this is huge, but multifamily communities are the second most common defendants in assault-related negligent security lawsuits. So that's everyone right here in this call. Like, you are susceptible to these liability lawsuits. Melinda, do you have anything to add to this?
It's just that it's all unfortunately very accurate. I have seen just across the board a rapid increase in litigation. Tenants are filing against their landlords, whether it's liability claims, whether it's discrimination, fair housing claims. Everything has just sort of exploded in the last couple of years. I think it started during COVID and has just continued to trend upward ever since then. In Maryland, at least, some of it is because of new laws that the state is passing to protect tenants and sort of tighten the noose around landlords. But it feels pretty much like a free for all at this point. If you operate a multifamily property and you have not been sued by a tenant yet, then I would brace yourselves because it's almost certainly coming. And even when the landlord wins those things, they lose. Because even if you take a case all the way through to the end, you go in front of a jury or a judge and you win, the ruling is in your favor, you've still spent a significant amount of time and money as far as legal fees and other things just defending the case. So that's why I say even when you win, you lose, because you're still going to be out money. And these plaintiffs who are being injured, they know, or at least their attorneys know, that the person who actually hurt them or caused the injury usually doesn't have a penny to collect. They want to go after the deep pockets, which is you guys. It's the landlords. That's where the money lies. That's where they can get these multi-million-dollar judgments for dog bites or being the victim of a crime on the property. So it is important to try and do what you can to prevent these things. I mean, obviously, prevention is ideal. If we can prevent it from happening at all, we're in the best possible position. But we also know that that's just not possible. So then you need to look at, okay, well, how do we deal with it when it does happen? And how do we protect ourselves, limit our liability to try and stop the bleeding, keep it as low as possible?
And you talk about when you win, you lose because of the time and the amount of money, but not to mention the negative publicity that comes along with it. The last thing that you need with, new prospects coming in to potentially lease an apartment is for them to hear from word of mouth or that negative publicity that something had happened on the property. They don't want to live around that, so they're going to move on to the next property. So we all know the ultimate goal is to keep your tenants safe, but also to keep your apartments full and have that high occupancy. So let's jump into it. Neighbor versus neighbor disputes. I think it would be best if we kind of start with, I know you have plenty of stories to share. So give us kind of your best story here, and then we'll kind of jump into some of the ways to handle them.
Well, I mean, I've had everything from murder from a tenant who shot and killed his neighbor over they were upset about noise to most recently I had a property where one of the tenants is complaining that her another resident is stalking her, and she knows for a fact that he is watching her through her walls, and she wants them to stop him watching her through her walls. So there's some things that you can address and you can take steps to handle, and there are other things that you cannot. I'm not quite sure how to stop someone from watching her through her walls, but I told the landlord to go in and inspect her walls to see if there were people living in there or if there were any kind of holes or any way that he could be watching her through her walls, and they did that, and it was pretty silly, but they had to do it. She, spoiler alert, did not believe them and maintains that they are still in her walls. It can run the gamut. I'm upset at my neighbor because I don't like the smell of their dinner coming through the vents to just they're noisy and I don't like them that way, all the way to violent altercations. A couple weeks ago had one where a tenant's guest had parked their car and was in their spot, but I guess was like not perfectly in the spot. And a neighbor came home, went to park in his own spot, had difficulty getting in there because of her car, and that escalated to the point where he broke her nose because he hit her so hard while she was holding an infant. So it can get serious and people can get really hurt. And there's not always going to be something that you can do to stop it. And there's not always going to be something that you should do to stop it. Typically, my number one piece of advice in this is don't get involved in interpersonal disputes between your residents unless and until you have to get involved. Because if you're perceived as choosing one side or the other, that is also a problem, right? So the first piece of advice that we have is to stay neutral as far as you can. De-escalate the situation wherever possible, again, if you can, whether that is you physically separate them, take one of them into the rental office if you can, just to get them away from each other. Sometimes that can help. If none of that helps, then you call the police. I don't generally recommend your employees put themselves in the middle of a physical situation, because then they can get hurt, and then you potentially have an issue with liability to your employee as well as liability to your other residents. If there is an opportunity to de-escalate things, to separate the parties, then that is usually a good idea. But it's always going to be situational, right? And a lot of times people are going to have to use their spidey sense or their intuition about whether or not they think it's a good idea to get involved in this, or to go lock the rental office door and wait for the cops to come. Sometimes that is the solution, is to just get out of it, stay out of it, and wait for law enforcement to come. Definitely document everything. Create a paper trail for everything. Without documentation, your attorneys, whether it's Offutt Kerman or another local counsel, have a much easier time when there is clear and thorough documentation of everything. There's incident reports for every time you got a complaint. There's copies of emails that the tenants have sent, all that kind of stuff. The more evidence that you have, the easier time that I'm going to have in court in a breach of lease or, defending a negligence suit. Most of the time, negligence suits hinge on whether or not there was foreseeability on the part of the landlord. Did you know or should have known that this was likely to happen? Had it happened before? And if you do nothing, then that's where you have a problem. But if you show that you've at least taken steps to try and fix the problem and you've done what you can, then that helps decrease your liability for something. Document everything. If you have video security surveillance, that's like my favorite thing in the world, because then it's black and white. That is what we call direct evidence. I mean, you can just watch it and see what happened. That makes my job much easier in trying to sort out who may be at fault, if both of them are at fault, if there's anything that the landlord can and should do. But obviously we understand not all the time there's going to be security video. So if there's not, then make sure you write it all down, and write it down as soon as possible after the event when it's fresh in your mind. That way, whatever you write down is more reliable. Make sure that you always keep fair housing in the back of your mind. Protected classes are something that you always need to be aware of in everything that you do as a landlord. Every time you stop and make a decision, you should also run like a fair housing analysis through your brain. Is there a fair housing concern here? Is there a potential protected class here? Is there something else that I need to do or not do to try and make sure that there's no blowback from that angle? Because that's the other thing that I'm seeing just a ton of these days are discrimination complaints. I used to get maybe 4 or 5 of those a year. Now I'm probably doing 4 or 5 a month.
That's huge. Yeah, thank you for going over all that. So, just a couple of questions. I mean, obviously, these are some of the things to do, but mentioned 1 in 4 multifamily properties face a liability lawsuit every single year. So you're telling everyone be prepared. What are some of the most common missteps that put landlords in legal jeopardy when it comes to resident altercations?
I think it's that they don't document what's
Okay.
going on. No incident reports, no notes to the file. They'll say, "Oh, well, we met with this person, and when we explained everything to her, and she seemed fine when she left the meeting." And I'll ask, "Well, when did the meeting happen?" "Well, we're not sure exactly. It was in April." "Okay, well, did you write it down? Did you make any notes to the file after the meeting of just this is what we talked about and this was the resolution?" No. That makes my job a little harder, because at that point there's nothing to prove. It's basically he said, she said, and at that point the tenant is probably not going to agree with the landlord's version of events. They're going to have interpreted that conversation in a different way. I think also sometimes landlords get a pitfall because they do take a side. They don't stay neutral. They take one side or the other, and then you can face claims of defamation. You've slandered my character because you agreed with my neighbor who's accusing me of watching her through the walls. So you always have to be careful about that. You are not the police, and this is not a criminal matter, but you don't want to go around accusing people of crimes without at least some sort of inkling that that's what happened, because then you open yourself up to liability potentially from the offender too. It's not just from the victim, it can be from the offender.
So staying neutral is obviously very important. You've mentioned that a couple of times. So if you have 2 residents that are constantly reporting each other, but that it hasn't escalated to violence, how should management document or intervene without appearing biased?
Again, it depends on the situation. I always look for, are there actionable lease violations going on from either side? Is there something that you could potentially evict them for in a breach of lease? And if it's just, for example, the complaints about noise, or we get a lot of complaints about incense and smells from smoke that are bothering other residents. If your lease has a no smoking clause in it and that person is smoking, that's a lease violation. That's something that you can and should address. But if it's a smoking property and this person is just bothered by it's kind of their problem. There's not a whole lot that you can do against the smoking tenant if they're allowed to smoke in their unit. Sometimes it's a good idea to maybe try and mediate, whether you have a sit down with all of the parties together in the same room and try and talk it out. Sometimes that will resolve it, but other times it won't. So that's why I say you got to rely on your gut and it's, your spidey sense to see if is this going to help or hurt the situation if I put these two people in the same room. And maybe it's going to hurt. If one of them is saying, if I see her, I'm swinging, it's on site. Well, then, okay, I wouldn't put those two people in a room together because that could get violent. And then that would be your fault because you put them together. But if you think that these parties are capable of talking to each other and staying calm, then why not do a mediation type thing? And if that is not possible, you don't think that's going to go well, then you can meet with them separately and kind of be a go-between for them to see if you can reach some sort of a compromise. They play their TV so loud that I can't go to sleep. And the other person says, well, but I turn my TV off at 11 p.m. when I go to bed. It's not, like it's in the middle of the night. Okay, well, would it be possible for you to turn down the volume at 10:30 instead of 11? And then that way your neighbor can sleep, but you don't have to. It's all about trying to find creative solutions, and it's never going to be exactly the same for each scenario.
Okay, so I knew we were going to get some good stuff from the audience. We have Angie that recently had a situation where a resident rented out the clubhouse to have a birthday party. It's a bit out of control, unsupervised kids throwing things, other non-guest residents. So that's a good point, kind of how to handle things when there's non-residents involved too. One of the residents pushed a child that fell. The parents who did not live at the property, but of the child, are now filing an assault case on a resident who is not part of the party. Police came in asking to see footage. Now the resident wants to see the video surveillance, so does the resident. Is it fair to not show the non-resident and resident any videos until the police finish their investigation?
That depends on where you're located. A lot of the laws governing this stuff are at the state level or even at the county or city level. So they can vary pretty wildly. In some parts of Maryland, for example, there is a law requiring security cameras on what they call high density units or buildings, which is at least 100 units or more. So those types of properties are now required to have cameras. And the law also dictates when and how they provide that footage to others, law enforcement, but also other residents and anyone with what they call a bona fide interest in the footage. So in your scenario, that would be the person who allegedly pushed the child, the parents of the child who was allegedly pushed. If that property was located in Prince George's County, Maryland, you would have to allow them to see the footage and provide it to them. Other places, you are not required to turn over your security footage. And sometimes it is smarter to not give that out because you don't want to give them the evidence to turn around and then sue you, right? If there's an ongoing law enforcement investigation, then I would think that you are okay to say, we've given it to the police. The police are working on this. We are not at liberty to provide you with anything else right now. If the police tell us that we should give it to you, we will. If the courts tell us that we should give it to you, we will. But right now, we're waiting to see what, if any, action law enforcement is going to take and how they're going to address the situation. You could just be a broken record. We are cooperating with law enforcement. We have provided them everything they've asked for.
And great question, Angie. Emily asked, what about when it's a lease violation, as in noise or smoke, but you don't know where it's coming from? Oh, that's a tough one.
That is a tough one. And that is a pretty frequent issue that I see is people will be complaining about noise and smoke. And sometimes that person is absolutely convinced that they know who it is, right? It's my upstairs neighbor, it's Bob to the left of me or whatever. But then management goes out to investigate it and they either can't smell anything, can't hear anything, or they hear it, but they think it's coming from the opposite direction. Sound travels weirdly in buildings, particularly in multifamily residential housing like this. It's interesting sometimes where noises are actually coming from. I lived in a condo for years and it was bizarre the way that the sound would travel. And I would be convinced that it was my upstairs neighbor doing it. And then I would find out later that it wasn't them at all. So I think obviously for you to take any sort of action against a tenant who may be violating the terms of their lease, you need some sort of proof that they are the ones that are doing it. when it comes to smoking. Usually, I think the best way to do it is to observe yourselves. Send out one of your employees into the hallway, see if they can determine where it's coming from. Ask the tenant who's complaining to give you guys a call when she hears the noise or when she smells the smell. That way, hopefully, there's on-site staff there and they can just go right over and see if they can witness it themselves. You need some kind of corroboration, right? If you cannot determine the source of the lease violation, sometimes you can send out a mass communication, a building-wide email. Hey, we're getting complaints about smoking. We're not saying that it's you, but if it is you, you better stop because we're prepared to take action. It's kind of an empty threat because you can't take action until you know who's doing it, but sometimes that's effective to deter people from doing it. And then other times there's nothing you can do. You can't seek to evict someone without any kind of proof that they are violating the terms of their lease and they deserve to be evicted. I mean, you can try, but you're probably not going to win that case. So at that point, it may be just more managing expectations with the tenant who is complaining. If it's possible to offer them a transfer to a different building or a different unit where they may be able to get away from the smell, then sometimes that works. If they just want to break their lease, that is usually the easiest way to resolve it, is just get them to sign some sort of a release so that they are not going to come after you with a lawsuit 2-3 years down the line. It's basically just it's a mutual walk away. We're going to let you break the lease and leave, and we're not going to pursue you, and you're not going to pursue us, and live your best life somewhere else now. Sometimes that's all you can do. There are certain tenants, I'm sure you guys know, who are just never going to be happy. They've decided that they hate your building and they don't want to live there. And so just let them pursue their bliss elsewhere.
And just to kind of expand on that question real quick, and then we'll go ahead and move on the slides. But Emily asked further, are we legally able to perform an inspection inside apartments when we've received complaints? Because that's what's being requested.
So again, it's going to depend on your state and sometimes your county. My knowledge base is Maryland, so pretty much everything I talk about is rooted in Maryland law. In Maryland, they just passed a law that is going to take effect in the fall that requires landlords give advanced notice anytime they enter an apartment, if possible, right? So if you're going to do an inspection, then you have to let the tenant know 24, in some places it's 48 hours ahead of time that you intend to enter and inspect the unit, which I think cuts down on the effectiveness of the inspection, right? If you're looking for lease violations and they know when you're coming and they have notice of that, they're going to hide their ashtrays or whatever else. Sometimes, not always. Sometimes I've had it that they walk in and the ashtray with all the joints or whatever it is just literally sitting right there. That makes it pretty easy to determine who it is. So I would recommend checking with your local council to see if there's any types of notice requirements before a landlord can enter an apartment. The exception to that, at least in Maryland, is if there's some type of an emergency, you are allowed to go in without notice. If there's a water leak or there's something on fire or you feel like someone is in danger, maybe you heard gunshots, God forbid, and you want to go in and make sure that nobody is dead in there. In those instances, you can usually enter without notice because it's an emergency. But elsewhere, you need to at least give some measure of advance notice to the tenant of your intent to go in. But I think that you can legally perform inspections when you receive complaints, and you should do that. The question is just, do you need to give a heads up or not first?
All right, let's go ahead and move on. So kind of transitioning to when and if the dispute turns violent. How do we handle that?
Yes, if you see physical violence happening, then you should contact law enforcement immediately. Call 911 right away. Don't wait, particularly since in some places, like lovely Baltimore City, they're not going to get there right away. It's going to take them a minute. More often than not, by the time law enforcement arrives, the conflict is over and one or both parties have left the area, which can be effective in and of itself, because if they know the police are coming, they run off, then whatever is happening has stopped, right? So you've at least been able to put an end to it right then. I do not recommend ever physically intervening. Don't put yourself between two people that are fighting, because that's going to make things worse. Now you've potentially got 3 people who are injured as opposed to 2. But if you are able to separate the individuals, if you think it is safe for you to do so, then you should do so, whether it's take one of them into your rental office or you have both of them go back to their apartments or go to their cars or whatever it is. Just try and get them away from each other so that it doesn't continue to escalate. I would always call law enforcement, even if they tell you there's nothing we can do, which happens more often than not, at least in my experience. If the police do come, they'll say, well, we didn't see it, nothing we can do. This is a landlord tenant thing. This is a civil matter. That person was just running around our building with a knife. Yeah, but it's a civil matter. But I would at least call them and make a report, because that goes back to the paper trail that I talked about earlier and the documentation. If I can show, this property has had to call the police 5 times in the last 3 months because of this tenant, that is a helpful fact in court that I can pull up. I can at least pull up the 911 call logs and show, all the calls that came in, because that lends credence to the story that something is going on here. May not establish exactly what happened, but it shows that there was an immediate concern at the time that it occurred that resulted in in the landlord calling 911 or someone else calling 911. So even if law enforcement doesn't do anything about it, you have established a paper trail just by calling them. Again, document everything. Document everything. Write down everything that happens. I want to know all of it. I would rather have too much information and too much documentation and not have to use it all than not have enough, and then the case is tanked. If there is and then the last thing on this slide, which I think is important, is that as far as your duty of care as a landlord, you are only going to be liable if there's a pattern of complaints of violence, if you had reason to know that this was an ongoing issue. So usually I will say, if it's the first time this has happened, is very unlikely that you are going to be found liable for anything that you did or did not do. If this is the 4th or 5th time that it happened, that's when your risk starts to go up, because you are aware that there is a pattern here and you have not done anything to address it. Even if you did something but it wasn't successful, it didn't help, that is enough to sort of protect you from liability, because you were taking reasonable steps to try and fix the problem. And, at a certain point, it's out of your hands.
And for sake of time, we're going to go ahead and keep moving through. We've got a lot of stuff to continue covering, but jumping over to the topic of sexual harassment. I'm sure
Yeah,
you have some stories.
I do. This one is tough. As a woman, I certainly sympathize with this and feeling uncomfortable. Men that make you feel creepy, or women, people that make, creep you out. Like that's a thing that we deal with. I could tell stories of my own about, people coming up to me and making comments that creep me out at the gas station or whatever. It happens everywhere. But there's not always going to be a scenario where the landlord can do anything about it, right? First of all, you have to be able to corroborate it. If you just have one person saying he's watching me through my walls, there's not a whole lot you can do about that. If you're getting multiple complaints from multiple other tenants about one person, that's when maybe you need to do something. Or if someone from your staff has witnessed some sort of harassment, that's when you need to do something. If you've got security cameras and you are able to see on the cameras that there's harassment happening, that's when you need to do something. Preliminarily, though, take every complaint seriously. Don't just blow it off. Listen to it, document it, write it down, whether it's an email from your tenant and you put it in their file, or they came into the office and you just write a little summary of what happened after the meeting and you put that in the file. You need to make sure that you document. Let the victim know that they need to continue to come to you and tell you when this is going on, because if you don't know that it's continuing to occur, you can't address it. They should also be probably advised that if they feel like they are being harassed or stalked in any way, that is an issue for law enforcement. And they should be reaching out to law enforcement and to put that on their radar too. Again, police may say there's nothing we can do because we didn't see it, or whatever, but at least that way they know you and your staff cannot arrest somebody, right? The police can arrest somebody. So that's why it is important to keep open communication with law enforcement and to recommend to your tenants that they also go to law enforcement. Most of the time, the police are not going to listen to you if you call and say, my tenant told me that they're being harassed. Well, okay, we need to hear that from the tenant themselves. Here in Maryland, there are restraining orders. We call them peace or protective orders, and there's all kinds of minutiae about that I won't get into. But sometimes it is up to the victim, the person who's being harassed, to take steps to protect themselves, whether it's seeking some type of restraining order, filing police reports to document it. The more documentation that you have and law enforcement has, the more leeway you have with what you can do. You can take action against something like that, whereas vague complaints are probably not going to do it. They're not going to be sufficient. Make sure that your staff is aware of what's going on, not to scare them, but just so that they know Karen and Chad have an issue. So if Karen or Chad come into your office, we want everyone on your staff to have some awareness and some knowledge of the back history here. Also, particularly if there are active restraining orders involved, it's not necessarily your job to call the police if you see Chad violating the restraining order, but you can. And if you know that there's a restraining order there and you're worried about Karen's safety, then sometimes it's a good idea for your staff to be able to call the police and say, hey, I think something's going on. Can you guys get out here? Add additional security if necessary. Had a couple of situations where tenants have actually caused serious physical harm. I already said the one case where the guy shot and killed his neighbor over noise. After that, I recommended that property have on-site armed security guards for at least the time that the shooter was still living on the property because he was out on bail. So we knew that he was violent. We knew that he had literally killed somebody and that he was a danger. So you have to do what you have to do to protect the rest of your residents from him. Had another instance where a tenant shot and killed the property manager and the assistant property manager. And that was another one where I recommended armed security guards in person in the hallways until we get this resolved, because you know that there's a serious situation. People are in serious danger here, and you need to do what you can to protect them. Sometimes the security cameras and the instantaneous monitoring that CloudStructure offers is sufficient and will also help with that. I know that security guards are very expensive. So that's never something that I've had a landlord say, oh, thank you so much. We can't wait to spend money on a security guard. But when I think it's necessary, I'll tell them that's what you guys have to do. Always reach out to your local council. If you have an incident like that, contact us right away, whether it's me or somebody else. Let your attorney know right away. That way you can start documenting everything, and you can start, you can hopefully get some advice about the best way to move forward, whether a notice to vacate, a breach of lease action is appropriate. If so, what kind of action? Do you give them a 30-day notice? Do you give them a 14-day notice, which is a thing here in Maryland? Things that you should not do is take sides. That opens you up to more liability than you had before. And don't make promises to either side that you can't keep. Don't promise that you will not tell your boss about this situation, because you need to tell your boss about this situation. Don't promise that you're going to get the other tenant evicted in 2 weeks, because you're probably not. Don't promise the one tenant, even though you usually will want to comfort this person, especially if they're a victim of sexual harassment or stalking or something like that, you will want to comfort them and make them feel safe. But don't make a promise that you don't think you can keep about keeping them safe or getting this other person out of the property. I would just not even go there at all. I would just say, you're going to work with law enforcement. You're going to do what you can. You're going to consult with your counsel, and then let them know, to the extent that you can, what the plan is going forward. Do not delay on action. The longer you wait in these types of situations, the more your liability is potentially going to be. It's going to be your inaction that sinks you rather than your action. So with these things, you want to jump on them right away. And also, you have to keep in mind that resident-on-resident harassment can sometimes have fair housing violations and fair housing concerns, right? So you always want to think about that. Is one or either of these people in a protected class? If so, then maybe I need to approach this a little bit differently. If your property is federally subsidized or some type of federal funding and you're subject to VAWA, the Violence Against Women's Act, you've got another piece of the puzzle that you need to consider. Do you have to make an emergency transfer of this person to keep them safe? If so, then you need to do that. You need to start working on that right away. I've seen discrimination suits recently where the tenant is claiming that both the housing authority, who handles their housing voucher, and the landlord did not act quickly enough to move them when they requested an emergency transfer because they were a victim of domestic violence. Now, if something happens there, God forbid that person gets seriously hurt or killed, and you already knew that it was an issue and you didn't act quickly enough, then you're in trouble.
as you guys can tell, a lot of responsibility does fall on the property manager to kind of handle these appropriately. So
Mhm.
really making sure that you're covering your bases. And yeah, this is all good stuff. So there's a good question in the chat by Cameo. If one resident has an order of protection against the order of protection from the court against a roommate, can we allow the other roommate into the apartment or change the locks and not give that resident a key?
Again, it's going to depend on where your property is located. Here in Maryland, if someone has a protection order or a peace order against someone who lives in the same unit, they live together, it depends on what the order says. If the order awards use and possession of the apartment to the petitioner, the victim, then you are, as a landlord, you are required to immediately change the locks. The second that the victim lets you know that they have this order and they've been granted possession of the apartment, you must go and change the locks. You can charge them the cost of changing the locks, but you have to get it done immediately. And then that other person just, they got to find someplace else to go. You should not allow an abuser or an alleged abuser back into an apartment if there is an active peace order. If you grant them access to the unit after they've already been ordered out, that is a big problem for you should anything go wrong. That is very clear liability to the landlord because they basically facilitated and allowed it to happen. So you should be careful with those. But at least in Maryland, it needs to be a final protective order or a final peace order. Those things go in stages. Person applies for an order. First, they're granted a temporary order, and that's good for a week, 2 weeks, whatever, as long as it takes for the other person to get served and be basically put on notice, at which point there's going to be a final hearing where the person who's being accused can either show up and contest it or show up and agree to the entry of a peace order or protective order, just basically saying, I'm not admitting that I did anything, but I'm fine with staying away from this person. Then an order goes into place, or they can contest it. They can, say, I don't want this order against me for whatever reason. I got to give up my firearms if I have them, or I don't want this on my record. I'm going to fight it out. And then there's a trial in court where the judge listens to all of the evidence from both sides and decides if there is just cause. I don't want to get into all the crazy legal terms, but it's a lower standard than in criminal court. It's not beyond a reasonable doubt, but it's a preponderance of the evidence. It's more likely than not that the person who is requesting this order is the victim of abuse or is in imminent danger from this other person. And the courts tend to be more liberal, and they will give these out more often than they will deny them because they don't want to be responsible for that either. I have seen cases where a judge denies a protective order for reasons, and then the next day the ex-husband went and lit her on fire at her job. So courts, and that happened in Maryland, gosh, probably 20 years ago now. But I know the judge that did that, and it did not go well for his career. And it obviously didn't go well for the victim who survived, but was terribly severely burned from that. So now judges are more likely to grant an order in an abundance of caution as opposed to deny it. So you want to pay attention to those things. I would recommend always reaching out to your counsel. If somebody brings you a piece of protective order or other type of restraining order, make sure you get a copy of the order from the tenant and send that over to your local counsel who can look it up. They can verify the existence of the case. They can kind of parse things out for you and let you know what you need to do as far as changing the locks, letting one person out of the lease or not, all those sorts of things.
And I do know Melinda keeps referencing Maryland. That's obviously where she's based and most familiar with those state laws. And obviously, it does vary from state to state. In case you guys missed it, there is a link in the chat where you can check the specific negligence laws for your specific state. So go ahead and check that out if you haven't already. And we are coming up on the top of the hour. So we're going to run through the next few slides fairly quickly. Melinda, jumping over
Yeah.
to domestic violence.
I know. I told you guys, I warned you that I would just talk my way through this whole thing, and here we are. So, domestic violence victims are considered a protected class by the Fair Housing Act. So, that's federally, and also in Maryland, they are also a protected class. So, you do need to always keep in the back of your mind that you're dealing with fair housing whenever you're dealing with a potential victim of domestic violence. You cannot evict a tenant because they're a victim of domestic violence. I most often see that in issues, usually to deal with noise complaints from neighbors. I can hear loud fighting and they're just going at each other at 2 a.m. every night. that is typically a lease violation, right? But you will not be able to evict the person who is a victim if he or she establishes that they are a victim and the reason for all of this was domestic violence. You can't kick them out of their apartment because they're being abused. There is a way to bifurcate or separate the lease, remove one person from the lease so that you can go after and evict the abuser, the offender. But it's a process, so you should always reach out to your local council. I know I sound like a broken record. Violence Against Women Act. So for HUD funded properties, then you cannot evict or terminate a lease because someone is going through domestic violence. You may also have additional obligations as far as transferring that person to a different apartment on your property or a different property that you operate or own if they request it, to try and get them out of the situation and get away from their abuser, at which point you can turn around and go after the abuser. And they do not get the same protections. They can and should be evicted for victimizing, their partners. But privacy is very important in those types of situations. You don't want to have a tenant complaining that, well, my neighbor told me that Susie in the rental office told her all about the fight that I had with my husband last week. That's a problem because that's a violation of privacy by disclosing another resident's status as a domestic violence victim. And I understand why it happens. Sometimes you may want to tell the other person who's complaining about noise, like, look, we understand, we're working on it. There's a domestic violence situation going on there, so we have to be careful. But you probably should not disclose that if you can avoid it. Just say, we're working on the situation, we're aware of it, we're consulting with our attorneys, we're trying to figure out what we can do and what we can't do.
Another great question in the chat and your quickest response to it, Melinda, but do the same protections flow over into unauthorized occupants? And if so, is there a time limit that the unauthorized occupant can be evicted?
So again, depends on where your property is. In Maryland, there are squatters' rights. And you can't evict half of a tenancy, right? You have to evict everybody. It's all or nothing. I have seen that too, where tenants will come in and say, look, I let this person in, they're not on the lease now, I want them gone. Can you get them out for me? No, I got to evict you too, because that is a lease violation on your part. Tenants are responsible for the actions of their guests, their invitees, their occupants, whether they're authorized or not. So that is technically a lease violation on the part of the leaseholder who let the unauthorized occupants in. You got to go after everybody.
You kind of covered some of these, but just to drive some of these points home quickly, and then we have a quick video that will show.
Yes. So assess the situation. Try and stay as calm as you can, right? Assess the situation as calmly as you can. You don't want to escalate everything by you getting all wrapped around the axle too. There's evidence of physical violence, or if you feel like this conflict is escalating and there's a likelihood for future violence, call 911. If not, if you think things are calming down, then try and set boundaries, try and separate them if you can, if that's a good idea. If you have some sort of a standard operating practice for your property, for all of your staff, so everyone knows what to do in these types of situations, and you keep it uniform, that is helpful. Document everything, write down every time something like this happens. The more documentation you have, the easier my life and my job is. Take photos if appropriate, log communications if appropriate. Make sure that if something has happened and you do have surveillance cameras, you preserve that footage. I know a lot of times footage will automatically rewrite or erase after a certain period of time. So you want to make sure that you don't let that happen. You save that footage in whatever process you have, so that when someone comes back to you a year and a half later because they filed a lawsuit, you won't say, uh-oh, we had the proof and now we don't. Make sure that you appropriately communicate and you are always aware of protected classes and potential fair housing. Make sure that your staff is safe. We never want your staff to be put in danger or to be harmed if they get involved in this, ever. So they should always be aware of their comfort level and their safety level, and don't jump into the fray with two tenants that are going at it to then just create a bigger problem. Make sure that all of your security measures are functioning. If you have cameras, your cameras should be working. They should be on and running. If you have a good relationship with local law enforcement, that can go a long way. Whether it's just one cop that you know because you're on his beat or whatever, get friendly with them to the extent that you're able to. Work with them when it is appropriate to do so. And that way, if they like you, their response time might be a little faster.
Okay, thank you for all of that, Melinda. So this is just a really quick video that we're going to play.
Mom, I'm sorry. I don't want to wake you, but I don't know what to do. I'm in the parking lot outside of my apartment, and there's this guy. I think he might be a resident here on the property, but he's been sitting in the car right behind me, watching me for like 40 minutes, and he won't leave. I'm just scared to get out of my car. No, we don't have surveillance here. I just don't want to drive all the way to you right now. I just want to go inside. Okay, I'll see you in 20 minutes. That was about a month ago. I was furious at being chased out of my own home. No cameras, no security guards. All I could do was tell the landlord the next day, but technically, the guy hadn't done anything wrong.
This place has more than just cameras. They have AI surveillance and remote guards, which means someone is always watching the parking lot at night.
Feeling safe at home is a necessity, and I'll never live without it again.
That video really highlights the importance of having surveillance, not only for protecting yourselves from liability, but also making your residents feel safe. They're going to want to stay somewhere where they feel safe. They're not going to want to live somewhere where they do not feel safe. So having those extra protective measures in place, like surveillance and remote guards, which are a fraction of the cost of an on-site guard, or even patrol services. There's a lot of ways that it can be used in conjunction to save you time and ultimately save you money, because on-site guards are super costly. So keep that in mind. I would love to chat with you guys more if you do need cameras or remote guarding services on your property. You'll see our emails at the end of this slide here. So any final questions that you have, go ahead and throw them into the chat. It is the top of the hour. So if you've got to go, totally get it. But I do want to show you guys, we have our next webinar scheduled for a couple of weeks out, next Thursday, August 14th. It's going to be about budgeting. So we know it's budget season. We're going to be talking with Ed Burnett, who was just featured on US News and World Report. So it'll be a great wealth of knowledge surrounding budget battles and how to kind of win those strategies for multifamily security. So go ahead and register for that now. There's a link in the chat. And any final questions, go ahead and pop them in. But that being said, Melinda, again, we're so happy to have you here and very grateful for your time. You have so much knowledge and experience to showcase and share with us, and it's super helpful. So thank you again.
You're very welcome. Thank you for having me. I'm always happy to do this. And to any of the participants who maybe have questions that they think of later, I believe my contact information is going to be somewhere in this. Feel free to email me, give me a call. I don't answer my phone, but you can try. I'm happy to continue this discussion once this webinar wraps up too.
Yes, thank you. So you'll see a poll that just popped up. If you want to automatically be registered for that budgeting webinar, go ahead and click yes, and we'll automatically register you. And then I did change the slide to my email as well as Melinda's email. So don't hesitate to reach out to either of us if you need some legal advice or whatever it might be, or again, if you need cameras or any type of security measures, we do free security audits of your property to kind of get an understanding of where you're at, where you kind of need to be to, again, make your residents feel safe and want to stay. So thank you again, guys, so much. This was a great webinar. Thank you, Melinda. Thank you to everyone that joined, and have a great day.